Hello everyone. Welcome to this info space, Nigerians informing Nigerians, where we share verified information on the state of affairs, happenings and events in Nigeria. To all our viewers yet to subscribe, please click the subscription button below and turn on the notification bell so you don't miss out on any info shared on this space. Also feel free to like and share this video on your platforms for other viewers to be informed. To the info I have for you. Here is the new schedule presented by the Presidential Election Petition Court. Please feel free to air your views in the comment section as you listen.
As Nigerians anxiously await the resumption of the Presidential Election Petition Tribunal, the court has released a new timeline. In the old timeline, judgment was supposed to be delivered in the first week of August, but in this new timeline, the date will be decided by the judges after the adoption of addresses. In other words, after all arguments, counter-arguments, and addresses by all the parties, the judges will take their time to look at the matter, after which they will now communicate the date that they will deliver the judgment. Now, let's look at the new timeline. As you all know, INEC will open their defense on Monday, the 3rd of July, 2023. They will have a few days up till Friday, the 7th of July, 2023 to defend the heist that they conducted. Yes, it was a heist. Evidence abound. All election observers, both in Nigeria and abroad, all of them came to the same conclusion, that the election was not transparent, that it was marred by violence and rigging. Why will Nigeria spend money into the billions of naira to adopt technology to make elections more transparent? At the end of the day, the electoral body, INEC, refused to use that technology to conduct that election. So on Monday, they will start to defend the indefensible. They've already set the tone if you watch the other video where the INEC Commissioner, Festus Okoye, was trying to play down the importance of IREV. So it will be interesting to see how they will base their arguments and how they will try to counter the massive evidence that they themselves brought to court. Because some of the CTCs that they delivered to Labour Party, they brought them to court by themselves. The next respondent after INEC will be Tinubu and Shettima. Of course, they are being represented by one council. They will begin their defense on the 8th of July 2023, just a day after INEC rounded up their own, and they will have until 13th of July to finalize their defense. It will be interesting to see how they will defend all the baggages. Where will they even start? Is it from the $460,000 forfeited to the United States government being funds traced to narcotics trafficking? Or is it the certificate forgeries? Or is it lying under oath? Or is it the dual nationality? Which one? Where are they going to start? How are we even sure of the identity of the man they are going to defend? So their defense will be very interesting. And if this hearing was being conducted live, it would have done a lot of damage to his reputation. That's if he had any reputation in the first place. Because when you look at the past, you look at all the baggages, all the allegations, they have gone beyond allegations because many of them are proven. The judgment against him in the United States happened. They are not denying it. They are only saying that it is now time-bound, that it has passed 10 years. On the other hand, they also claim that it was a civil forfeiture. But we all know how it started. How the FBI special agent, the DEA, and other agencies started the investigation, and his name kept popping up. All the people that were arrested and sent to jail all named him, and how he lied to the FBI when he was questioned over the telephone. So all these exist. It's just that they are banking on all sorts of technicality to say, yes, he did it, but no, like they said before, that it was his account. Yes, it's actually one of their responses to the Labour Party petition, that it was his bank account that did the crime, not him. So it will be interesting to see how they will defend him, starting from the 8th of July. Starting from 14th July, APC will have the opportunity to open their own defense. They will do this till 17th July 2023. APC will have the opportunity to tell the court how they were able to win the majority of the votes, despite bringing Nigeria's economy to its knees. Despite not winning any of the KKK states. They didn't win Kaduna, they didn't win Kano, they didn't win Katsina, they didn't win Lagos, they didn't win Abuja. All the major cities across Nigeria, they lost woefully. Where exactly did their votes come from? After APC's defense, there will now be the closing of evidence starting from the same day, 17th July. From 28th July, it will be the time for respondents to address the court. They will have that opportunity to address and say all the reasons, all the objections they have been objecting, everything presented in court, all the evidence that were tendered. They will now have the opportunity to tell the court, this is the reason we objected to this is the reason, this, that. So after their own address to the court on the 28th July, of course, it might be more than that, the petitioners, that's P2B, Labour Party, and Atiku, PDP, they will have their own time starting from the 5th of August. Possibly this is the time they will mention the number of votes that they got in court. They will even go as far as mentioning how many states they won and how many states they got 25%. Every detail about the election will be revealed by this time when they address. After their own address, the respondents will also have another opportunity to reply their address. That will happen on the 11th of August. The next day, being the 12th of August, will be the adoption of addresses. After this stage, the judges will now adjourn to look at the matter, go through all the evidence, write their judgment, and when they are through, they will now communicate the date for the judgment, because the judgment will be read as usual. The lead judgment will be read, and if there are dissenting, they will also read theirs after the lead judgment has been read. Now, let's answer some questions. Constance wants to know how INEC will open their defense against non-compliance going by the preponderance of evidence. Well, they've started already. when Labour Party presented the expert witness from Amazon, who submitted reports that proved that there was no glitch on election day. So INEC already responded to this by saying that there was a glitch, that it was the glitch that caused the non-upload of presidential election results. We all know that this is not possible. Let's even assume that there was a glitch. It would have stopped all uploads. House of Reps and senatorial elections can be uploading while the presidential election will refuse to upload. It's just impossible. The second part of your question can be answered because you can't get into the mind of a judge. It's just because of the Nigerian factor. Ordinarily, when you look at the law and look at what section that was breached, you should be able to look at the punishment and say, yes, there's no way this person is surviving this. The law must catch up with the person. But you can never know how they will decide. That's it. And we just keep an open mind till the judgment day to see how they will overlook all these. Of course, you must have confidence because when the trial started, they said that they must look at every matter based on their merit. No room for technicality. So we keep an open mind, unprejudiced, and keep watching till the judgment day. This brings us to another question that many have been asking. They want to know the chances of P2B and the Labour Party winning at not just the tribunal, but also at the Supreme Court. Just like I already said that you can't get into the mind of a judge, but there are things you look at and you have hope. You say, there's no way this man will escape this. There's no way they will look at all this and turn a blind eye and say it is because of this or use one technicality to strike off the matter. For instance, the current CJN was among the people that delivered justice when they said that forfeiture is because a crime was committed, that one cannot willfully forfeit something without committing a crime. That if the government wakes up one day to seize your property, whether in the bank or physical property, landed asset or anything, that you have the right, when you know that you didn't do anything wrong, you still have the right to go to court and challenge the government and you will win. This judgment was made in the case of Mohammed Abacha versus the federal government. We made a video about it. So looking at that case, will they say a different thing this time, considering the fact that Mohammed Abacha didn't go to prison for it and his own wasn't even drug related? Also, what he mentioned is that there are 2 Supreme Court justices that were part of the panel that disqualified a PDP candidate in the House of Reps for certificates forgery.
To all our viewers, thanks for watching. Don't forget to like and share, as well as subscribe to this channel and turn on the notification bells so you don't miss any update from us. Love and peace, guys.